Good afternoon. Today, Brian, an unemployment benefits expert at the Oregon Employment Department, joins us. In today's webinar, we will spend the first half focusing on school employees and reasonable assurance. And then the second half will focus on parents who are unable to work due to school closures. Afterwards, we will take as many of your questions as we can in the time we have left. Please remember that we cannot look into or resolve one person's own claim status in this public forum, and it is not safe to put your personal information in the chat or question boxes in this public recorded webinar that will be posted online. Please post your questions in the Q&A box and not the chat box in the Zoom meeting, and we will take as many of them as we can after we finish the discussion with Brian. The Q&A box is located in the middle of the bottom bar of the Zoom window. So let's get started. Let's start by talking about who is a school employee for unemployment purposes.
A school employee is anyone who worked for an educational institution during the base year of their claim. The base year is the period that the claim is based on, usually the first 4 of the last 5 completed quarters. You can see this information on the document that we mailed you. It's called a wage and benefit report, showing the wages and the weekly amount you are entitled to receive.
Does this mean that the person needs to be a teacher or otherwise working directly with students?
No, this simply means that you work for an educational institution doing any kind of work. You could be a receptionist or a doctor or a parking lot attendant that never actually interacts with students. You may not have even worked in the school building, but we still have to review your claim during each recess period to determine if you are eligible to receive benefits.
So can you explain exactly what is a recess period?
So when we talk about the recess period, we may also use other terms like break period. What we are talking about is the time when students are not typically in the school for a specific institution, program, or location. Common examples of a recess period are like winter break, spring break, summer break. It must be customary, a customary break period that is established. So it cannot be something that occurs without prior notice or scheduling. Every year we gather information from institutions in surrounding states regarding what the break periods will be. We use this information to determine the periods that we need to review to see if a claimant has reasonable assurance if they claim during those time periods.
Can you please explain what reasonable assurance is, the review process, and why do we need to do it?
Of course, school employees may be eligible to receive benefits during the normal period between school terms or academic years if the individual does not have reasonable assurance. Generally, reasonable assurance means you have an offer of work doing similar work to what you were doing prior to the break, making at least 90% of what you had made in the prior year or term. Federal and state laws require that we review claims for all individuals to determine if they are eligible and if they're claiming unemployment benefits that have wages from an educational institution in their base period. Normally, the department would mail out a questionnaire with the review questions. However, this year, due to the fast increase in claims, we didn't do that. Now an adjudicator will contact you directly to ask you the questions. We also request information from the schools or other educational institutions.
What about those who work at an educational institution but currently cannot work due to COVID-19?
We still have to review their claim. Specific individuals, such as those in janitorial or facilities maintenance who are exempt. However, we must give the school and the claimant the opportunity to tell us what their job duties are. Sometimes we can tell from a job title if an individual is exempt from the provisions, and sometimes it's just not clear and we have to ask more questions. Individuals who quit work with good cause from their educational institutions are considered to not have reasonable assurance with that school or institution. However, if they have an offer with another school or institution, it's possible that they could still have reasonable assurance and might not be able to use their educational wages to establish the claim.
What about substitute teachers? Do they need to go through this process even though they are not full-time at one school or multiple schools?
Yes, if they have wages in the base year of their claim from one or more educational institution, and this doesn't include for-profit companies that substitutes sometimes work through, but substitute teachers are reviewed under the same laws as any other school employee.
What about those who say worked for an educational institution last school year, but their most recent employer is not an educational institution?
Well, first we determine if there are base year wages from an educational employer. Then we ask the claimant if they were employed by that educational institution during the prior period or school year. If we can tell from the wage record or information that we have from the employer that they had not worked in, say, the 2019-2020 school year, we would, for an educational employer, we would not set the file up for review, and we would begin paying them if they were otherwise eligible for benefits.
So how long will it take for someone's claim to go through this review process?
Unfortunately, due to the mass amount of claims in adjudication, the wait for review is currently at about 14 weeks. We continue to hire more adjudicators to try and alleviate this backlog and this wait time and get to benefits to Oregonians faster. We have a group of adjudicators that are dedicated to investigating these specific files.
Do school employees qualify for the Benefits While You Wait program while their claim is waiting to be reviewed?
It depends. Specific cases could be eligible based on certain criteria, but others may not be eligible. So the Oregon Employment Department staff are still contacting people who may qualify for this program. You don't need to call us to see if you qualify, because we are examining the files to see who might qualify and reaching them out to them directly.
Okay. And also, how will it work when school starts back up? Do workers get their benefits again then?
Yes, so schools report to the Employment Department their recess dates or periods. Those dates are uploaded into our system, and if someone requests benefits for a week of that recess period, then we need to review the file in order to see if they can receive benefits. Once those dates end, and if they're still requesting benefits, the weeks outside of that time period would no longer be flagged and would process normally, even if we haven't had a chance to review the break period yet.
Thank you, Brian. So now we're going to move on to parents who are unable to work due to school closures. Do they still qualify for unemployment insurance or pandemic unemployment assistance?
Yes, so under our agency's temporary rules, parents who are unable to work due to school closures are still eligible to receive benefits. This also applies to parents who are unable to work due to a lack of childcare because of COVID-19. Pandemic unemployment assistance also has an eligibility criteria of school or facility closures, which includes childcare or other programs someone might normally need in order to work.
Just so everyone knows, these temporary rules are on our website at unemployment.oregon.gov. So what if someone has to quit their job in order to care for their children due to school closures and lack of childcare? Would they still be eligible even though they quit?
Yes, but the claim may still need to go through adjudication to verify that the parent had to quit due to a COVID-19 reason. Under the Pandemic Unemployment Assistance Program, an individual who quits their job may not be eligible if the employer was offering them the opportunity to work from home with pay or was offering paid leave to the employee.
Okay. How should they answer the questions on their weekly claims that pertain to school and childcare now that school is going to be back in session soon?
So for the upcoming period, school year, our determination would be a claimant is eligible under the stated COVID-19 impact reason, especially for PUA, if the facility is closed as a direct result of the COVID-19 public health emergency, and such facility care is required for the individual to work. For both regular UI and PUA, the department has determined a facility is deemed closed if the physical location is closed at least 3 days of the week, excluding Saturday and Sunday. And there is no option to attend in person. If the option to attend the facility in person exists and the claimant chooses an online option, we would need to adjudicate to determine the specific circumstances, and the claimant might still be eligible based on the facts of the case.
Okay. Thank you, Brian. So with our remaining time, we are going to be going to our Q&A box to answer some of your questions. Please remember that this is a public forum, so do not put any confidential information into the Q&A box. All right, let's see. What do we have? Okay, so Scott Bernard would like to know, what about school bus drivers contracted through the school district or coaches? Wait, I'm confused.
I just put them all together.
Oh, okay. So this is one full question from several people. Sorry. So what about school bus drivers contracted through the school district, coaches for school districts, or auxiliary non-professional higher ed workers?
Okay, I want to make sure I wrote that down so I got to all three of them, because there are actually three different situations. Bus drivers that are contracted through the school district through a secondary employer like First Student or First Student Management, those wages are not coded as educational wages. When the employer gets a business ID, or then the wages they report have certain codes to them. And if an employer has a educational institution code, that's how we know to flag the files. If someone works for a private employer like First Student Management, those wages are not coded as school employer wages, so they would not be set aside for this particular screening. Coaches who work directly for a school, the same provisions do apply. We're looking at a lot of different factors. Every season is a little bit different. So we would look at what kind of work the person normally does, and also what the next school year is going to look like. Now, there is another part of this, is that a lot of the coaches that work in Oregon do so on a part-time basis. So unfortunately, we have to hold the file while we research the school employee part of it. But sometimes claimants can establish a claim outside of the school employee wages. We just have to review those and then make a decision about those particular wages. And non-professional employees of higher ed would still need to go through this review, although sometimes higher ed has a different recess period than a lot of the elementary and secondary schools in Oregon. So each educational employer may have a different recess period that they report. Sometimes it's a week and sometimes it's the entire summer. So each one of those will be reviewed individually based upon what the school's recess period actually is.
So this is from an anonymous attendee. Do school employees qualify for PUA if they don't qualify for regular unemployment, or if the adjudicator says they don't qualify during the recess period?
So our federal guidance is pretty clear on reasonable assurance. If somebody is ineligible to receive regular unemployment insurance benefits due to reasonable assurance alone, they would not be eligible for PUA benefits.
All right. So I don't know if this is one that can be answered, but Carson wants to know, why are claims still pending for district substitutes, considering that there will be 0% or close to 0% of regular hours to return to, what then will the funds be expected?
So every district in Oregon has different plans about returning and how they're going to return. So we can't make decisions on these files district-wide. We have to give the employer a chance to provide information. It's part of their due process under the law. We are trying to reach out to school districts and different schools as a whole and asking questions about all of their employees, because some schools do not have a plan, and some schools have an idea of what they're going to do and can already provide information about what it's going to look like for substitutes in the fall. We are trying to reach out to these different school districts individually and answer these questions as quickly as we can. But sometimes if the school district doesn't know, or if they are providing information that mirrors prior years, because the decision really hinges upon the offer the employer makes. And then we have to, as an agency, examine the facts of each case for and weigh the credibility of whether or not it's likely that that person is going to return in a similar capacity.
Okay. So Nanette wants to know, how do I phrase this? So if she took a new job outside of the school, and it's a temp job and it ends in December, should she refile for unemployment using her old claim if the district is still closed next year, or will she need to file a new claim since she worked for a non-related business? Non-school related
That one's a little bit more difficult to answer since everyone's claim year begins and ends at different times, and it may coincide with an educational employer's break periods, or it may not. So someone's only allowed to file one unemployment insurance claim per calendar year. If you worked for an employer just very recently, chances are those wages aren't going to fall into a base year until about a year to a year and a half later. So most likely, if you had just recently worked for a different employer, a private employer on a temporary basis, those wages aren't going to impact your ability to collect unemployment until sometime in the future. So most likely, it would be better just to keep the claim that you already have and wait for an answer as far as the adjudication goes. Sometimes someone may be impacted by COVID-19 in different ways. And if someone was working a part-time job or a temporary position and it ended due to COVID-19, then they might actually have a different set of circumstances to file a PUA claim under. So we are still recommending, even though we know that from the federal guidance that those who are denied regular unemployment insurance benefits due to reasonable assurance most likely will not be eligible for pandemic unemployment assistance, we're still recommending everyone file. That way we can examine everyone's individual circumstances and so we don't miss anyone.
Cliff would like to know, my school district or their school district just informed them that all staff will start normally, but they will begin staff reduction after the start of the school year. So if an employee is laid off or furloughed, will the employee be eligible for benefits retro to the recess or summer period?
What we're going to be examining for the summer period, for the recess period, is whether or not it is likely the employee will be returning to the same type of work under similar economic conditions. And our administrative rule defines that similar economic conditions of having earnings within 90% of the prior school year. So if we're comparing one school year to the next, we are looking at whether the employer has provided information that the person would be earning within 90% of the previous year. If the employer has already announced that there's going to be layoffs and furloughs, the adjudicator would take that information into consideration as they made their decision regarding reasonable assurance. So it's definitely something that you would want to tell your adjudicator when they contact you, as well as when that offer was made. As far as whether we can pay retroactive benefits based upon employer changes, sometimes there are conditions in which, depending upon when the offer came and when the school year starts, and when we receive the information, that we can look at prior weeks. Not always, it also depends upon the type of work someone performs. But it's definitely information that you want to record, you want to write it down and make sure that you can provide it to the adjudicator when they call you and ask questions about the offer that you've received.
Okay. All right, someone would like to know, their case is under adjudication, but their regular unemployment claim expired last week. Should they file for the 13-week extension or the PEUC while they wait on the adjudication so that they can continue to file a weekly claim? Or how should they handle that since they're still waiting for adjudication?
If their claim year ended, they would file a new unemployment insurance claim. If they have wages to establish the new claim, or if they haven't earned enough since the last time they filed a claim, the first step would be to determine if that claim would be eligible for benefits on that new claim. If they weren't eligible for benefits on that new claim, then they would go to the PEUC. Right? They would file an extension on the prior one. So the claim specialist that helps you file your claim will help you with that process and explain it.
Yeah.
The good news is that when the adjudicator reviews it, they're going to review reasonable assurance for both claims at the same time. They're going to go ahead and investigate the first claim or the prior claim that you had filed, and if any decision carries over, they can go ahead and enter it on the new claim. You won't have to wait a whole nother set of weeks for whatever weeks remain of the recess period.
Okay, so they should just continue. So if their claim is still valid, they should just continue on with the extension, and then the adjudicator will help them with both
Yeah,
at the time.
that's correct.
Okay. Alrighty. So now we're going to move on to some questions from parents who can't work while their kids are at home or out of school. So if you have teens in school and school is online and your child will not do the work without a parent being at home, what would a parent tell the employer, or would this fall under a COVID-19 reason? I think it's more for if they have a teen.
Mm-hmm. So there's a couple of different things going on here. One is if you have a teen at home or any child at home and they're not able to attend school because it's online and you need that child to be home, it could potentially fall under our temporary AAA rules, able and actively seeking work rules. That depending upon the age of the teen, obviously teens cover any range from 13 to 18. So that might play into it as far as a factor, as well as the abilities of the child themselves. So we have a process of investigating different situations in any environment where a parent is unable to work due to a child being at home. As far as how you interact with your employer, that I can't advise. Every employer is different. Some are subject to different federal laws and Oregon laws, and some are not. It just depends on the employer. I would just be honest with the employer about what's happening, and then if the employer is unwilling or will not allow you to stay home with your child, you could file an unemployment insurance claim, because under our temporary rules, if you have a child at home and the school that you need them to attend is closed, you may be eligible for unemployment benefits. Additionally, part of our rule that we're going to be examining that I read earlier is that if the option to attend in person exists and the claimant chooses an online option, we would need to adjudicate and determine the specific circumstances. This is going to fall under that area where it's not always black and white, and if there is an issue, the adjudicator is going to listen to all of the details of your situation and apply the rules accordingly.
Okay. Christina would like to know, what if a parent needs to reduce their hours to be home with their children because they're doing school from home? Is there a long wait on unemployment for parents who have to reduce their hours? So they're not fully quitting, they're just reducing.
It depends on how far they're being reduced. When someone files a claim, they're assigned a weekly benefit amount. If they work or earned wages that exceed that amount, then they may not be eligible for unemployment benefits anyway, because they're not technically unemployed as defined by the law. Otherwise, most of our COVID-19 rules and our temporary rules read that if you are unemployed or are partially unemployed. So having reduced hours would fall under that umbrella of having being partially unemployed.
Mm-hmm. So I think this question was answered earlier, but we will ask it again just to make sure everybody knows. What about parents who quit to care for children who have to do online schooling and don't have the option to telework?
That would fall under one of the COVID-19 situations. If you quit a job due to a COVID-19 situation, it's considered to be good cause. It still might need to go through a review for the adjudicator to get all the details and verify the information depending upon which program someone's being paid under. But that is potentially a situation that is a voluntary leaving for a COVID-19 situation under the CARES Act. One of those situations is specifically if someone has a child or someone else in their household they care for that they need to have a school or daycare be open in order for them to work. And if that school or daycare is closed and they have to stay home, that's a COVID-19 specific situation.
So this one's from an anonymous attendee. So say someone filed a claim back in March, received their benefits, went back to work, so they stopped filing, but now they have to quit their job due to distance learning for their children. Would they have another waiting week, and would their claim need to go under investigation?
It depends what program they're on. For PUA, we ask the question, and if someone marks that they have quit for a COVID-19 related situation, we don't automatically stop the claim. We will still contact the claimant to get additional information. If the claimant is on a regular UI program and they mark that they voluntarily left the work, an adjudicator will contact them for additional information. There wouldn't be an additional waiting week. There's only one waiting week per claim year. So if you've already served a waiting week on this claim, and you're just reopening an existing claim or filing what's called an additional claim, since you have been working for the past few weeks or months, there wouldn't be an additional waiting week. As far as the wait, adjudication is unfortunately about 14 weeks right now. However, some of these situations may qualify for benefits while you wait. So as people come in and out of the unemployment insurance programs, we are examining claims to see who would potentially qualify for those programs and who wouldn't, and it's an ongoing evaluation, let's put it that way. We didn't just look once to see who would qualify to reach out to them. We are constantly analyzing our claims to see who would qualify for it and then reach out to them for information and to let them know.
All right. So you might know what this acronym is. I'm not sure, but so are the provisions the same for people who work for the ESD and not directly for the school district?
So ESDs are educational service districts. They're usually districts or organizations where many districts pool their resources. You might have 5 or 6 districts that cannot afford a psychologist, so you have several pulled together to have. So there's different rules for ESDs and employees who work for ESDs. Sometimes employees who work for ESDs never set foot in a school if they work just in the ESD office alone. We actually would have to contact them and the employer to verify that. But if they spend more than 50% of their time in the ESD office, then the provisions don't apply to them. However, if they are like a substitute teacher and more than 50% of their work is performed in the schools within the ESD, the provisions would apply and we would need to do an investigation.
Okay. This one comes from an anonymous attendee. As a school employee, if we have to decline work and take a voluntary layoff due to being identified as being in a high-risk category or needing to stay home to assist our younger students with their online learning because of the school closure, are we still able to claim unemployment benefits?
So there's a lot of different things going on there. We were never going to tell anyone not to file a claim and not to request benefits. We would always encourage everyone to file a UI claim and request benefits for each week until we've made a determination on eligibility. So there's a couple of different things going on there. One is a COVID-19 situation where if you have a child at home and you have to remain, whether you're a teacher or you work in a factory, we don't weigh the type of occupation. If you have to be at home because your child is at home because of a school or facility closure, that's a COVID-19 related reason. We would still need to do an investigation, of course, verify the information. So it would need to go through adjudication, but there would be potential UI eligibility in that situation. Now, if someone voluntarily leaves work and it's due to a situation that's not a specific COVID-19 specified situation in the CARES Act, then we would do our normal voluntary quit investigation. We would contact both parties and gather information about the reason, what alternatives there might have been, and whether it's something that a reasonable and prudent person would do. So it doesn't mean you would be denied benefits. It means that we would have to apply the rule and law under a different category and still conduct an investigation.
So it looks like we have time for one last question. So are you, I'm just trying to see if I can phrase this correctly. Caitlin would like to know. Okay, so are you able to describe what it looks like to file for an extension and what does that process entail? So I'm guessing in this situation it would be a PEUC extension, but if you could explain both PEUC and extended benefits, that might be helpful.
Okay. So there are two different programs. One is called PEUC, or Pandemic Extended Unemployment Compensation. That is also a part of the CARES Act. That extends a claim that has either expired or has run out of funds within a certain time period. It adds 13 weeks of benefits. If someone is in continuous claims, meaning they've been claiming for the last 10 weeks and then it just ran out, the process is fairly automatic. We screen for those, and then since the PEUC is the next step, we go ahead and file one. They may reach out to you for information, they may not, but usually those are just filed. If there's any kind of break in reporting, or we have to move from one program to a different program, there is an application online that you can fill out. It looks just like the Pandemic Unemployment Assistance application. It's located on the online claim system. There's a link for it. And then you would just fill out the form and submit it. And we have people in our regular UI centers review those and then file those applications.
Great. All right, well, thank you, Brian, and thank you everyone for attending. We are going to close out today's webinar right now. It has been recorded and will be posted on our YouTube, Facebook, and Twitter, either later this evening or early tomorrow morning. Please follow our Facebook and Twitter to find out what our next subject for next week's webinar will be, and we look forward to being able to answer more of your questions come next week. Thank you again.